This show is intended to help listeners understand the new opportunities that are now available to college and high school athletes as it relates to name, image, and likeness. The information contained in this show is only meant for educational purposes and is not meant to be legal advice or to establish an attorney-client relationship. Hello, and welcome to Court with the Esquire Coach. I'm your host, Cassandra Ramsey, a sports and entertainment attorney in the Washington, D.C. metro area, and I love to talk about all things sports, entertainment, and the law. In today's episode, we're going to cover a variety of topics. We're going to talk about NIL Collectives, what they are and the role that they play in this new college athletics NIL landscape. We're going to talk about Alston Awards, the overlooked opportunity for college athletes. We're going to highlight some notable figures in Black history and college athletics. We're going to talk about notable NIL deals. And lastly, we will get into the latest in college sports news, and it has been a lot of news. So let's get started. So today will be a very informative show, and I'm really excited to get into it. But before we get into the show, I want to talk about a headline that I saw that I think needs to be discussed, as it's going to help me make sure that I clearly explain the purpose of the show and the resource that I hope that this show provides. I saw a headline that said that Deion Sanders believes that parents have become wannabe agents, misleading kids on NIL deals. Upon looking further into the headline, I saw that he was on a podcast where he explained how college athletics is changing in football recruiting, and how some parents are maybe have unrealistic or unbelievable expectations for their for their kids, and how they may, not on purpose, but just because they don't have the knowledge that an agent has, or the training that an agent have to be able to effectively negotiate these NIL deals, that they may be misleading their kids or not getting the best deal for them. So this headline really made me think about my show and what I want to do with it. And my purpose is to provide a NIL resource where you can come and you can learn about NIL. If you're a current athlete or a future college athlete or the parent of one, you can learn what it is. You can learn what things you should know about. If you look at my previous episodes, my first one I talked about what NIL is. In my next episode, I talked about state NIL laws. I highlighted Maryland and Virginia, as they both have a state NIL law. I talked about the D.C. Proposal, because D.C. does not have a state NIL law. And then I went into what you should do if you are attending or considering a school in a location that doesn't have one. You look at the school's policy. If there's no school policy, then you rely on the NCAA's policy. So I hope that with this show that I can provide that resource where I talk about all of these topics that are related to NIL and what you need to know. So please continue to check out my show, and we're going to dive into today's topics. The first topic that we're going to get into today are NIL collectives. So when college athletes were first granted the right to profit from their name, image, and likeness, it was meant for college athletes to be flexing their entrepreneurial muscles and garnering their own deals with third parties. Schools were not intended to be involved, and at that point, nobody really could conceive an NIL collective, so it wasn't any thought that another entity would be involved. It would just be the athletes garnering deals with a third party. And for the first 2 months, that is what happened. As soon as NIL started, we saw athletes taking advantage of their opportunities. For example, we saw a Jackson State University football player, Antoine Owens, who entered a NIL deal with a Black-owned grooming company called 3 Kings Grooming. We saw the Cavender twins ink a deal with Boost Mobile. And athletes were, really taking advantage of their opportunities. Enter September 2021, we see the creation of the first NIL collective, known as the Gator Collective. This was an organization that was formed to support the athletes at the University of Florida. So what is an NIL collective? NIL collectives are organizations created by alumni, boosters, or businesses with the purpose of providing NIL opportunities to their school's athletes. And NIL collectives are formed independent of a university. The Gator Collective, the first one was formed by former University of Florida baseball player Eddie Rojas, with the goal of leveling the NIL playing field and increasing NIL opportunities for athletes and future athletes at the University of Florida. While the Gator Collective has been dissolved at this point, there are approximately 225 NIL collectives in existence. About 92% of Power 5 or maybe now Power 4 schools have at least one NIL collective or are in the process of forming one. And all 14 schools in the SEC have a NIL collective. So from this, you can see how important NIL collectives are, or how important it is for you to know what they are, how they work, and what their purpose is. There are various types of NIL collectives. Let's get into the first one. The first one is a marketplace collective. Marketplace collectives create an opportunity for college athletes to connect with businesses to discuss potential NIL opportunities. Marketplace collectives are great marketing tools for college athletes, as they provide college athletes with an opportunity to market their personal brand and connect with businesses that are looking to do NIL deals with them. In some instances, marketplace collectives act as an agent representative for the athletes. The second type of collective is a donor-driven collective. These use a model that pools funds from boosters, business entities, and fans via a subscription service. The subscription service provides contributors special access to events ran by the collective where players make appearances. And the third type of collective are called dual collectives. This type of collective combines a marketplace and a donor collective together to form a dual collective. Dual collectives feature both a marketplace and offer a place for supporters to give donations. The fourth and final type of NIL collectives are called player-driven collectives. These collectives are powered by a company called Yoke, whose website describes it as the premier Web3 company providing technology for athletes to build community and receive equitable compensation for NIL. Under player-driven collectives, the organization is led by the players, while the Yoke company provides the infrastructure. NIL collectives are a major player in this NIL landscape, as roughly 75% of NIL compensation during the 2022-2023 academic year came via a NIL collective. This is why it is important for current college athletes, future college athletes, and their parents to know what an NIL collective is and understand the role that they play in NIL. Many NIL collectives service all college athletes at the college or university that they are attempting to assist. However, there are some NIL collectives that have a singular focus on a certain sport, and it's usually a men's sport. For example, the Arizona Assist Collective has a focus on men's basketball. And this presents an issue, especially when it comes to women's sports and women's opportunities for NIL deals. I stated earlier that NIL collectives made up about 75% of NIL compensation. But when you're talking about women's sports, that percentage goes down to 34%. So if you are a women's college athlete, or the parent of one, or the parent of a future women's college athlete, this is something that you would want to be aware of and look into and consider, as you want to make sure that you're going to have equitable opportunities for you as a women's college athlete. This has also brought up a broader concern as it relates to NIL collectives and Title IX. So I said earlier that NIL collectives are created independently of their school. However, many of them have close relationships with the school, and it has led college athletes' rights advocates to question whether NIL collectives should be held to the same standards of Title IX, or whether they should be required to provide equitable opportunities for both men's and women's athletes. And this issue is currently being addressed with a recent case that was filed against the University of Oregon, asking these very questions about the responsibilities that the university has to make sure that their associated NIL collective is providing equitable opportunities. There's currently a case pending regarding Title IX and NIL collectives. 32 women's college athletes at the University of Oregon filed a class action discrimination lawsuit against the University of Oregon last December. The plaintiffs allege that the University of Oregon is violating federal law by depriving athletes of equal athletic financial aid and other resources, such as benefits that Oregon's athletes receive through Oregon's NIL Collective Division Street and the platform Open Doors, which is Oregon's official NIL marketplace. Division Street is a separate entity from the University of Oregon, as it is a NIL collective, and I stated earlier that NIL collectives are created independent of their college or university that they support, but a relationship between the university or college often exists. However, the plaintiffs are attempting to hold the University of Oregon responsible for what they describe as disparate opportunities that Division Street provides to female athletes compared to those that are provided to male athletes. Basically, the plaintiffs are arguing that Division Street provides more opportunities to male athletes, and that results in unequal treatment of women's athletes. Title IX is a federal civil rights law that prohibits gender discrimination in education programs or activities that receive federal financial assistance. Most colleges and universities receive federal financial assistance. Accordingly, they have to comply with Title IX. This case will be an interesting one to follow, as a lot of people in college sports are debating if NIL collectives should be subject to Title IX, or if a college or university has a responsibility to ensure that NIL collectives comply with Title IX. Last year, I wrote a law review article discussing this very topic. I discussed how NIL collectives are presented with this Title IX issue, and that whether Title IX should apply really depends on the relationship between a NIL collective and the school that it associates with. And oftentimes, there is a strong relationship. Like, the school may list a certain NIL collective on its website. They release press releases discussing that they are going to work with a certain NIL collective. So those things do signal that there's a relationship, which would lead one to argue quite reasonably that the school does have a responsibility to ensure that that the NIL collectives provides equitable opportunities to both men's and women's athletes at their university. In my paper, I went on to discuss ways that schools could go about ensuring that their associated NIL collectives are compliant with Title IX. And I argued that they could make sure that the schools provide equitable opportunities by taking the same steps that they themselves as a university are required to take in order to demonstrate that they are compliant with Title IX. In my paper, I state that athletic departments could ensure that NIL collectives are compliant with Title IX by requiring them to demonstrate that the NIL opportunities that they offer to male and female athletes is substantially proportionate to the number of men's and women's athletes participating in intercollegiate athletics at their school. Or the NIL collective could demonstrate Title IX compliance by showing that its offerings are meeting the interests and demands of both male and female athletes despite any showing of disproportionality. I suggest that the athletic departments create compliance guidelines for the NIL collectives that require the collectives to provide equitable opportunities for both men's and women's athletes. And I suggest that they host education seminars to teach the NIL collectives about Title IX and why it is important that the schools remain compliant, and how the NIL collectives can help the athletic departments meet their goals. And lastly, I suggest that the athletic departments conduct a audit of each NIL collective yearly to ensure that they are complying with the guidelines and providing equitable opportunities to both men's and women's athletes. The next topic that I want to discuss is one that I believe is a very overlooked opportunity for college athletes. And it is overlooked because it comes from a case that always gets mischaracterized as a NIL case. This case would be NCAA versus Austin. Austin is not a NIL case. The case has nothing to do with NIL. It's just that when the Supreme Court announced their opinion, it was right ahead of college athletes being granted the right to profit from their NIL that people conflate the two and mix them up and think that NCAA versus Austin led to NIL. That is not at all what happened. Those are two very separate topics. So let's get into NCAA versus Austin and what came from that for college athletes, which are called Austin Awards. So, very briefly, what happened in the NCAA versus Austin was West Virginia football player Sean Austin and other college athletes sued the NCAA, alleging that their rules limiting the amount of education-related benefits that college athletes could receive violated federal antitrust law. The athletes argued that the NCAA could accomplish their goal of preserving amateurism in a less restrictive way by continuing to restrict non-education related benefits, but no longer restricting education related benefits. The district court agreed, the appeals court agreed, and the United States Supreme Court also agreed in a 9-0 decision. So from that, it was determined that officially the NCAA's rules are subject to federal antitrust law and that the NCAA cannot restrict the amount of education related benefits that college athletes are able to receive. So from this case, you have something that is called Austin Awards, which is another benefit outside of NIL that has nothing to do with NIL that college athletes may be able to receive. So, what are Austin Awards? Austin Awards are educational and financial rewards provided to college athletes directly from their school. College athletes may receive up to $5,980 annually in Austin Awards. Education-related benefits can include things from musical instruments, computers, to scholarships for graduate school or vocational school. After the ruling, some schools created Austin Awards programs. For example, the University of Virginia has the Cavalier Academic Achievement Fund, which rewards UVA's college athletes for the academic achievement up to $5,980 annually. UVA college athletes are eligible to receive these awards through the Department of Athletics Pathways program. So in addition to NIL opportunities, if you are even a current or a prospective college athlete, you should be aware of what Austin Awards are and see if the schools that you are considering have them and if that's an opportunity that may be available to you. Now we're going to get into some of this week's notable NIL deals. And the first one comes from Maryland native Angel Reese, who made history as the first college athlete with personal branded apparel at a major retailer. Angel Reese, who is also known as the Bayou Barbie, has the Bayou Barbie collection available at Dick's Sporting Goods in Baton Rouge, Louisiana. The collection features casual and athletic wear, crop tops, and hoodies. The collection can also be found online. In case it is still not clear that college athletes have value, look no further than this story. Women's basketball star Caitlin Clark's 2022 Topps Bowman University Superfactor rookie auto card sold for $78,000 in the PWCC January premiere auction. This sale is 6 times higher than the previous most expensive women's basketball card owned by former University of Oregon star and now New York Liberty star Sabrina Ionescu. This just shows the value of college athletes. My first Black History Month highlight is the legendary Coach Eddie Robinson of Grambling State University. Coach Robinson spent 57 years coaching and had an unprecedented record with 408 victories, 165 losses, and 15 ties. Coach Robinson set the NCAA's benchmark for wins in Division I. On October 7, 1995, Coach Robinson became the first college football coach to break the 400-win barrier with a 42-6 win over Mississippi Valley State. Coach Robinson coached many notable players, one being Paul Taint Younger, the first athlete from an HBCU to play in the NFL. Coach Robinson also coached Eunice Buck Buchanan, the first player from a HBCU to be chosen first overall in the NFL draft. In 1997, Coach Robinson was inducted into the College Football Hall of Fame. My second Black History Month highlight is Coach Willie Jeffries, who became the first Black head coach of a Division I-A football team in 1979 when Wichita State University hired him. Prior to coaching at Wichita State University, Coach Jeffries coached at South Carolina State University, where he became South Carolina State's winningest coach. Coach Jeffries won the MEAC conference title 7 times, 6 being with South Carolina State University and 1 with Howard University. Now we are going to get into some college sports news. This first story addresses a topic that we talked about today, NIL Collectives. Houston, Texas quarterback C.J. Stroud made news as he became the first professional athlete to donate to a NIL collective that is associated with his alma mater. Remember when I mentioned donor-driven NIL collectives? This is an example. At the conclusion of an impressive NFL rookie season, as C.J. Stroud made it to the NFL divisional round with his team, Stroud also earned a roster spot in the 2024 Pro Bowl. Stroud donated to the foundation, a NIL collective that supports Ohio State University football and basketball. Remember when I addressed that some NIL collectives focus on 1 or 2 sports? Here's an example of that. The amount of the donation was not disclosed, but Stroud was labeled as a platinum donor, and donors are given a platinum donor designation if they give $50,000 or more. Stroud donated as he wanted to support the NIL collective that assisted him in obtaining NIL opportunities when he was a college athlete. Many have questioned how sustainable NIL collectives will be and if NIL collectives will be able to raise the necessary money to support the athletes that they wish to assist. But having a pro athlete donate to your NIL collective can certainly be a way to help with that issue. So do you think that C.J. Stroud has started a trend? Will we see other professional athletes donating to their university's NIL collectives? The NCAA is facing yet another case. In January, a case that is before the National Labor Relations Board regarding the possible employment status of college athletes resumed at the NLRB's regional office in California. In February 2022, the National College Players Association filed unfair labor practices charges with the NLRB against USC, UCLA, the Pac-12 Conference, and the NCAA. The charges seek to affirm the employment status of D1 FBS football players and men's and women's basketball players. The hearing began in December and resumed earlier in January. And however, the complaint is only being prosecuted against USC, the Pac-12, and the NCAA because UCLA is a public school and not within the jurisdiction of the NLRB. The players are seeking to show that they should be considered employees because of the amount of control that USC has over its athletes. Control is a very important factor when trying to determine if an employer-employee relationship exists. The more control that a party has over the other, the more likely it is that that type of relationship exists. USC had a former running back, Brandon Outlaw, testify during the hearing that football players spend an average of 50 to 60 hours per week on football-related activities and another 30 to 40 hours in the off season. He also testified that USC attempts to control the players' social media and what they say to journalists. However, lawyers for USC, the Pac-12, and the NCAA are attempting to paint a very different picture. They're trying to paint college athletics as an extracurricular activity. The USC lawyer analogized participating in college athletics to participating in the USC marching band and even to participation in high school sports. This case has the potential to have major ramifications for college athletics, as it could completely end the NCAA's amateurism model if college athletes are deemed employees. The professionalization of college athletics is ever increasing, and this could be evidenced by the conference realignment that's taking place, where we're going to have cases where college athletes will be traveling all over the country to compete in their sport, thus requiring more time, which helps bolster the argument that there is a significant amount of control and time required that may lend itself to an employment relationship. So whether college athletes will be deemed employers, and at least in this case, remains to be unseen. However, the likelihood of college athletes being deemed employees just took a turn to being much more plausible, as the news broke that Dartmouth men's basketball team, who petitioned the NLRB's office in Boston seeking the right of college athletes to unionize, was just granted the ability to unionize from the NLRB's regional office in Boston. The National Labor Relations Board ruled that Dartmouth College men's basketball team should be considered employees and can hold a union election. The NLRB reasoned that Dartmouth College exerts control over the athletes and the compensation that they receive. While Ivy League athletes do not receive athletic scholarships like other D1 programs, the NLRB regional office found that the other forms of compensation that they receive to be sufficient. Other forms of compensation such as apparel. A spokesperson for Dartmouth College stated that the school would be appealing the ruling. It is important to note that this is not the first time that a college team has petitioned the NLRB for the right to unionize with initial success. In 2014, football players at Northwestern University petitioned the National Labor Relations Board for the right to unionize. Kane Coulter, who was Northwestern's star quarterback, teamed up with Ramogi Humor, the founder and president of the National College Players Association, and they petitioned the NLRB for college athletes' right to unionize. And Coulter and Humor experienced initial success with the NLRB's regional office in Chicago, which ruled that college athletes met the broad definition of an employee and as such could form a union. However, Northwestern appealed, and the ruling was not held up by the NLRB's national office, as they refused to assert jurisdiction over the case and dismissed the case. So the national office did not address the pivotal question of whether college athletes could unionize, but they instead refused to assert jurisdiction, reasoning that college sports the national office did not address the pivotal question in the case regarding college athletes' right to unionize. They just refused to assert jurisdiction. So this left the door open for other programs to pick up the baton and take off running again. And that is exactly what Dartmouth's college men's basketball team did. And they have experienced some success that the school has already made clear that they will appeal. While they plan to appeal, things have changed since 2014 when the National Labor Relations Board's national office refused to assert jurisdiction. Back in 2021, the NLRB's General Counsel, Jennifer Abruzzo, issued a memo suggesting that college athletes are employees under the National Labor Relations Act and should be afforded all protections. So in this memo, she pretty much made clear that if anything regarding this issue came across her desk, that she would be leaning towards stating that college athletes should have employment status. So this memo and this outcome in the Dartmouth case is very significant, and I think will have implications on the ruling in the USC's case. So, this is, again, a very exciting time in college athletics. Things are ever changing, and I will be keeping you guys up to date with what is going on in both of these cases. Thank you for joining me today. As always, I hope you found this information helpful, and I will see you next time.